A fairness opinion must disclose any material relationships that existed during the prior 2 years between the firm rendering the opinion and any party involved in the transaction. All of the other choices are true. The rule has nothing to do with the merit of an investment. By law, when a company has an outstanding tender offer to acquire another firm's stock, neither the acquiring company nor any of its officers or directors may purchase an equity interest in the target or anything convertible or exercisable into stock. Straight debt is not convertible into equity, therefore, this purchase is in compliance. Quiet period expirations are the dates upon which a company's registration for an IPO are approved by the SEC. Once a quiet period is over, an analyst may release information to the investing public. The minimum quiet period is 10 days, but in many cases the member firm underwriting the offering may require a longer period to fulfill all of its legal requirements. The legend subject to completion or amendment must be printed in red on a preliminary prospectus, red herring. SEC Schedule 14A is filed to provide financial information and other important procedures for shareholders' meetings. Non-convertible debt and non-convertible preferred stock offerings are exempt if they are rated as investment grade. Also exempt are Regulation D offerings, U.S. government and agency securities, municipal securities, mutual funds, and unit trusts. A final prospectus must be delivered under separate cover. Section 402 of SOX prohibits personal loans made to officers by the company. A customer is considered long and can tender if he owns the stock. If the customer has provided conversion instructions for a convertible bond or exercise instructions on rights, warrants, or options, this customer would be considered long the stock. An analyst must exercise diligence, independence, and thoroughness when performing investment analysis, making a recommendation, or taking investment action. If the member firm wishes to use a report that diverges from the analyst's true feelings and expectations, the analyst may request that his name be removed from the report. If an analyst is, however, satisfied that an analyzing team's process produced results or conclusions that are reasonable, the objecting analyst is not obligated to dissociate from the report, even when it does not reflect his opinion. If the terms are changed, the offer must be opened for at least 10 business days from the date of change, but never for less than the original 20 business days. The member must disclose this control relationship before the trade settles. If a member receives an order from a conduit such as a bank, the member must make an inquiry as to whether the ultimate purchaser is restricted. It is not necessary to determine the identity and business affiliations of the purchaser. SEC Rule 503 requires that issuers of unregistered securities file Form D, Notice of Sales Made, with the SEC within 15 days of the first sale. Note that it is not required under the safe harbor of Regulation D for the issuer or its placement agent to register the securities. Each OSJ, FINRA Rule 3110-D, states that within 10 business days of the end of each calendar quarter, a written report describing each internal investigation initiated in the previous calendar quarter by the member firm must be submitted to FINRA on its investment banking activities. The price to be reported through NASDAQ/TRF excludes commissions, markups, and markdowns. NYSE rules require that all open orders, both above and below the prevailing market, be automatically canceled in the case of a reverse split. In a forward split, the number of shares will be increased, and the price will be decreased appropriately. Any communication between research analysts and investment banking personnel regarding research reports must be made through a legal or compliance official of the member firm. When computing its reserve requirement monthly, a broker-dealer must have on deposit 105% of the calculated amount. The excess of credits over debits is the formula. In selling stock subject to Rule 144, members must act as agents unless they are market makers in the subject security. In this case, they could buy as principal for their trading account inventory. FINRA rules prohibit principal underwriters of investment company securities from selling below the pop unless the buyer is a member firm. A written selling agreement exists between the two firms, and the buying firm is filling customer purchase orders already received. Under no circumstances may members make a market in mutual fund shares. FINRA provides that the requirement to obtain written permission from the employing member firm to open a securities account at another financial services firm is not applicable to transactions limited to unit investment trusts. Municipal fund securities, qualified tuition programs such as a Section 529 plan, and variable contracts or redeemable securities of companies registered under the Investment Company Act of 1940. Member firm testimonials concerning the quality of its investment advice must state that it is not a guarantee of future performance, and the person writing the testimonial must have enough knowledge of the subject covered to form a valid opinion. The testimonial must represent only the investment experience of the author, not that of other customers. The rules do not preclude paid testimonials for competitive fees, although they must be presented to the public as such.